Good evening, this is the May 24th meeting of the Zoning Board of Appeals. First up, we have a reserved decision on appeal number 2018-016, JLL Properties.
I move that the determination of JLL Properties Corp. by Jose Berta at 1312 East Main Street, Riverhead, tax map 600-105-1-20 for the special exception per chapter 301, section 222B, where there is proposed change for a pre-existing non-conforming auto parts shop building to a non-conforming deli, specialty food shop, and a non-conforming barber shop, personal service business, to be granted in accordance with the application and sketches with the amendments thereto, if any, as filed with the building inspector. And I attach the definitions shall be applied to the approved non-conforming delicatessen use on the premises. Further, this approval shall be conditioned upon the approval of the site plan by the planning board.
Second?
Mr. Barnes?
Nay.
Mrs. Worthington?
Aye.
Mr. Whitmire?
Aye.
And I vote aye. So your appeal has been granted, but with the conditions, you have to go before the site plan board, the planning board, and have it approved. Okay. Next up, we have an extension, a request for an extension on appeals 17-14 Schroeder.
Okay, on Schroeder, I move that the appeal of Kenneth Schroeder, originally granted April 27th, 2017, for a variance to and relief from provisions of Chapter 301, Section 17, where the proposed front yard is 40 feet, the minimum required is 50 feet. The proposed side yard setbacks are 15.9 feet and 21 feet, where the minimum required is 25 feet. The proposed combined side yards is 36.9 feet, where the minimum required is 55 feet. And the proposed rear yard setback is 41 feet, with the minimum required is 60 feet. Be it extended in time so that the permit can continue, non-pro-tunc for the period of 1 year, thus expiring April 27th, 2019.
Second.
Mr. Barnes?
Aye.
Mrs. Worthington?
Aye.
Mr. Whitmire?
And I vote aye.
And I vote aye. So the extension has been granted. We have another extension. That's on appeal number 16-35, Carson Farm Country Kitchen. Mr. Danowski, would you have a few words?
Pete Danowski, representing Farm Country Kitchen and its principals. As you know, I've been forwarding some information with regard to the completion of the site plan process, in particular the requirements set forth in the resolution of approval, which was granted by the planning board in August of 2017. The requirements included covenants and restrictions and cross-access easements. They also required not only the owners of 3 separate parcels as represented by my clients, but also each of 3 distinct separate mortgagees to consent to the requirements. That included reaching out to representatives of one of the lenders in Dallas, Texas. It included, at the end, them emailing a signature and them saying to my clients that they've emailed that they don't have to send an original, to which we said, this is difficult enough to get people in Dallas, Texas to agree to some signature for a town of Riverhead, but to then suggest that they're not going to forward the original is kind of crazy. But eventually we just got the original, so we were able to go to the county clerk's office and record the originals and transmit those to the town with certified copies distributed. So now we're at an approach of going to the planning board and asking for the chairman to sign the site plan approval map. The problem, in addition to that, is really an unusual condition set forth, and I know you folks are aware of the generic requirement for any client which again, I'm not sure is in the town code, which says we in the town of Riverhead are taking a position by way of policy that we're not gonna let you clear the land, even though you may have it partially cleared already, in this sense, the parking lot I'm really talking about, until you pull a building permit. Now, I understand the logic has been told to me as to why the policy exists. Policy exists because the town may have had a prior bad experience where someone cleared their land after a site plan approval and never pulled the building permit, so that the land was cleared but the building wasn't built. That, however, is really an aberration, an exception, and not something that I think is set forth in the code, where you can say to me, as many clients do, that, geez, they've got a site plan approved, all the conditions of the site plan are met, and they won't let me clear the land to get a running head start to build until I get my construction drawings done for a building. And what that does, it sets up another problem, because, as you know, the town has a policy as well, that when you want to do a site plan, and if there's any requirement for a variance set forth in what you plan to do, you must begin with the Zoning Board of Appeals. And you have a standard that you set forth in decisions saying there's an expiration date. That expiration date is so much shorter than you can possibly get with the planning board. The planning board site plan is for a maximum of 4 years. So we all know that I wish there'd be an amendment to the code so that the zoning board decisions would be for 3 or 4 years, so we didn't have to come back and bother you every year and say, please give us an extension because we're not out of the site plan process yet. And I'd love to have the confidence that we could get through a site plan in this town in 1 year, but I know better. My experience is it's many years to get through the process depending on the size of the project. So we have to come back before you all the time saying we're close to getting everything done, except we need another extension of the zoning board decision, which is where we are. And if we get denied an extension, we start with a new application for a variance, a new public hearing, asking for the very same relief that this board has given us. This one's even more challenging because the conditions set forth in the resolution of approval out of the site plan process in the planning board in several instances are almost unheard of, and that is the highway permit issued by the DOT and by the town in the town road calls for bonding, and it calls for bonding to be set forth. And who normally does the bonding for anybody's project? It's the contractor. The contractor is going to pull the permit. The state DOT has said the permit will issue. Here's your letter. Come and post your bonds. All right? We've got to hire the contractor. That contractor we're going to meet with next week. We're going to have a global meeting and say, will you post the bond even though we haven't gotten the building permit yet, because we can't get the building permit yet until the site plan map is signed. Map can't be signed until I get the actual highway permit per the resolution. So I have to get the contractor to take the risk on that we wouldn't get a building permit, and he's going to have to post the bonds for the 2 highway jobs before the planning board chairman will sign the map. And that hopefully will be discussed next week if this extension is granted. So I really want to explain to you that when guys come in here, people come in here and say, you need an extension to the zoning board decision, we'd love it that we wouldn't need it, that we would get a site plan signed by the planning board chairman and a building permit with construction drawings completed and issued by the building department within the 1 year's time. But seldom does that happen, and it physically just won't happen from job to job. Now, when you have a residential home with a variance, yeah, there's a good running shot that you get your construction drawings done when we leave you. We apply for anybody else's variances that are needed, anybody else's permits, and we come in here and try to get it done within a year's time. But it just generally doesn't happen. And I want you to know that if you look at the detail that's contained on the covenants and the cross-access easements that by agreement required, you know, it takes time, and when you have to go back to the banks to get the consents, it's again a big headache. And I always think back to, in my last bit of attempt at humor tonight, I once had a health department required covenant to get consented to, and I had to deal with a gentleman in India and try to explain to him, because they outsourced the work, that this is a Suffolk County, New York Health Department covenant that I need you in India to sign off on. And it was extremely difficult to get through that process. So I do appreciate you allowing me to speak in behalf of this tonight. I would ask you to grant this extension, where we are so anxious to get this built. And I will say this, that even during the site plan review process, even at the very end of it, I made a request that was addressed to the planning board with planning staff there. Could you allow us to use the parking lot, to improve the parking lot any way you want, with some form of temporary granting of permission, so we could clean up the parking lot and use it while we're reaching the finish line and the rest? And they said they could not do that. So recognize that I need the signature on the planning board approved site plan, and then I need the issuance of the building permit before I can construct. Construction means finish off the improvements. But I will be meeting next week, and I will be meeting with the contractor in attempts to see if he'll post the bonds.
Question, Peter.
Yes, sir.
The lot that's on Sweezy Avenue.
Yes, sir.
As you know, the current use is a landscaping yard.
Right.
That we granted a variance on
Right.
back in the 90s.
Mhm.
None of the conditions were ever met, not to anybody's fault, because the prior owners never complied.
Right.
The current owner has continued to rent it, which the business world is the business world, I get it. That lot will be cleared for parking for Farm Country Kitchen.
That's correct.
Will there be any other backpedaling or consideration for the lot he purchased on Main Street itself, where he has a sign now that says parking Farm Country Kitchen?
We'd love to use that as well, but, you know, will
I
that
can
be
under-
granted? I wouldn't know if it would be or wouldn't be.
I can understand you wanting to leave it out of the site plan process because it would
No, I think it was.
throw a monkey wrench into the whole thing.
No, I think the ability to control that property didn't come until after these approvals were
Oh, I
gained.
understand that, but he must have intentions that he would like to use that.
No, I think, well, there's no question, if you own a piece of property, do, but I think that the end line is here that I'm a positive supporter of the applicant. I am many times, and sometimes I don't take certain clients because I don't think whatever they want to do is nice. I think it's a real positive for the town. I wish other people would take riverfront property and clean them up and use them in the nice way this is done. And to the extent that the neighborhood gets improved and looks better than it did, and I think you're aware this was a transmission shop, or
Yeah.
if I'm right, that my client's use of it for whatever purposes would be a major improvement than what was there before. And I wish other folks would go along the neighborhood, including along the riverfront. And I've been a big fan of taking a greenway system along the river, and I'll think back to Mr. Stark, former day as supervisor, and some of the other people that were trying to do this, and say, open up the vistas of the rivers like some other few towns have done, and let us see the river. And if that means public acquisition of buildings along that riverfront, let's have that happen, so you have a walkway and a greenway there. And there was some positive feedback that the state would allow that to happen. And I was always a fan of saying, let people build on the railroad track side of that West Main Street area. Even allow a transfer of density if that's possible. It made more sense. And as you know, and I know, Mr. Barnes, your background and your knowledge, that it got stonewalled because of the State Rivers Act, which was another major headache. And
Still is.
it was never meant, that state law was never meant, as you know, that it goes beyond a public improvement like a roadway. And it just, we got into this wild and scenic nomenclature, and now I know been adjusted a little bit, and I'm happy to see some things are happening. So,
Well-
from my end, the neighborhood and the improvement that Farm Country has done to the area will be a benefit to the town. So, I agree with those that say, hey, when you get a popular place, you need more parking, and this is a proposal that adds more parking. I think that's just a major benefit.
So, he intends to evict or ask his tenants to leave
Yeah, well, yeah.
before he cleans that out.
He will clean it out as soon as the town, and nobody else will be there besides him. It's a condition of the approval anyway. And he'll do it, he would do it today if someone said you temporarily get permission to do it. Done. But I've tried that approach, and I tried it even during the approval process. Why wouldn't you allow us to use it?
I don't think the town has the foresight to think of a way to do it. Because it's not legislated.
Well, let me tell you something. If
They want to live by the legislation, by the law. They
I-
don't want to be creative and think out of the box and try to do things to help people. That's just government, and that happens a lot. But I'm willing to vote for it, but one of the problems I've had for many years is that it's never come into compliance from the variance we granted back in the 90s.
Let me tell you, if somebody
And
would.
it's been an eyesore, that's all.
All I'm saying to you, I agree with the eyesore comment, and I'm saying, I've tried my best to move this, and I'm trying next week to move it. And it is, everyone would have to, I think, acknowledge it's an unusual requirement to say to me they won't sign the map until I get the highway permits issued that they know have to be bonded. And why wouldn't they, as they've always done, do that as a requirement of the issuance of the building permit? As I'm going for the building permit, I go for that. But and this is a parking lot construction too. This is not like your average building of a building. So that's my comment on the day.
Thank you, Peter, for
Thank
your
you very much.
comments.
All right, I make a motion that the extension for appeal number 1635 be extended for 1 year and be expiring on June 9th, 2019. Do I hear a motion?
So moved.
Second.
Mr. Bonds?
Aye.
Mrs. Worthington?
Aye.
Mr. Whitmire?
Aye.
And I vote aye, so your extension has been granted, Mr. Danowski.
And again, I apologize for my appearance tonight. Mr. Cuddy has his jacket and tie on tonight.
Mr. Danowski, and I understand why you had a problem with Dallas. Obviously, they found out your uncle used to be the quarterback for the Giants back in the day, so. New York Giants are not very popular
I
down.
really don't want to comment more. I might get my client in more trouble. Thank you very much.
Thank you, Peter.
Thank you, Peter.
Okay, held over from the last meeting, appeal number 2018-21. Let's see, who do we want to get up?
Okay.
Do we have any, on the fencing, we have any solutions? Anybody get together and talk about it? Go ahead,
Neighborhood.
come on up. Let's get it going. You've been sworn in already, just state your name and your address.
Donald McIntosh,
Just pull that mic up to you a little bit. Thank you.
Donald McIntosh, 75 West Alfred Avenue, Bainham, New York, 01933. I would just like to see a copy of the plans, please, that I haven't seen, and just to look to see where the fence is going, and if I'm happy with that, then you won't hear from me again.
Okay, well, let's see what you folks have a outline of where you'd like that fence? Because the one we have.
Do you have a copy of that, so he could see it? The one that they submitted?
Why don't you come up and I'll give you a copy? So you can.
Yeah, ours is in email form, so.
Again, this is what they propose.
Okay.
And what-
Can I just look at it for a few minutes?
Sure,
Come
take
back?
it, sure, take it in the back.
See if anybody else wants to.
Yeah, anyone else want to speak on this matter? Come on. remember you from the last meeting?
No, I wasn't able to come.
Just pull that microphone down a little bit.
Sure.
You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
Please state your name and your address.
My name is Roberta McGray. I live at 35 West Alfred in Calverton.
What lot number is that?
I have no idea. I'd have to see a map. I'm new to the neighborhood. We just moved in last July.
So you're a new kid on the block? huh?
Yep.
Okay, let's hear it.
You got it? Why don't you come up and see Leroy and just point your spot out? Leroy, where's the camera?
Yeah. Which one would be you? Okay, it's lot,
This is the last one, so it must be right here.
okay, you are
Look at my
lot
eyes.
9. Is that, you wanna look quick? I hope so.
Oh, wow.
Pretty good, right?
These are pretty good. I might have to take these.
Costco. Flex frame,
Yeah, lot 9.
okay.
Thanks.
So he proposes the lot, the fence in your backyard.
Yes.
Are you opposed to that or for it?
I'm kind of concerned with the height. It is kind of tall when you go out in the backyard. I feel like maybe 8 feet might be a little too high. I mean, the deer fence is, pretty see-through, which is good. I like that. But when you go outside, it's quite tall. So I have a concern with that.
Okay.
I mean, I don't know why, like, a 6-foot fence wouldn't do the job, but I don't know. I know
Single
something
leaf.
about trees being by, but the trees are by their house, so I'm not sure why they're fencing in the whole 9 acres. So I'm concerned as to what's gonna happen after this.
They're
too.
putting up an 8-foot fence because deer can make a 6-foot fence.
Right, but I think
So-
the protected area that they're trying to protect is not in this, whole 9 acres. I feel like, and I haven't gone over to their yard and looked around, but I feel like, I think they have these trees that they're trying to protect, and I believe they're very close to their home, not all the way down on my side of the world.
Well, we had talked about a potential compromise, and we were talking about asking them if they would be okay with moving the fence, like 50 or 70 feet from the rear property lines of everyone else. Either 70 would be their building envelope, or 50 would be,
I think that would be less intrusive.
well, I feel that way too, but I would have to hear what
My
other
neighbors
people
say,
want to
yeah.
say, and what the owners of the property want
Right,
to say. But
Of course.
I could tell you from my own vote, I couldn't vote for the way it is proposed at the moment.
I mean, it's up in my backyard. It has been since they began. The neighbors that are east of me, they don't have it up yet, just the poles. So if you want to come to my house and take a look and see what it looks like, you're more than welcome to come over. And they are more than welcome to come over too, because you're like, whoa, it's pretty big.
I can understand them wanting to
Hey,
fence
I'm all
the
for
whole
protecting
thing,
your land.
you know, to protect their
Yeah.
property and their trees
I
and pear
understand that.
trees. I get all that, but having a fence on top of your backyard, I don't know if
It's
that's
kind
what
of
it was
daunting.
meant to be. So, I don't know. Okay, Mr. Chairman, I'm done. Anybody else want to ask? Would you be okay moving it, what, 50
Yeah.
feet this way?
Down to the building lot line, right?
Yeah, I would even compromise 50 feet back if the neighbors are agreeable to it, instead of 70. If they're agreeable, that still gives them a little more room for their plants and whatever.
Okay, thank you very much.
You're welcome. Thank you.
Let's get the applicants up. Come on, man. Just state your name and your address. You've already been sworn in.
Wendy Huang, 65 West Alfred Avenue. We're
Okay.
the property owner.
Mhm.
2 weeks ago, we were here, and
Right.
the board counselor requested us to submit a original survey with the plan drawn, with our property line drawn, which we have submitted. Our property line is highlighted in pink and yellow. I don't know if you have the same.
Yeah, we do.
right? So the yellow one that's highlighted, it's already has existing fence that the homeowner has installed in their backyard, a 6-foot fence.
That's 6 foot.
Yes, correct. This whole highlighted with yellow and pink are our property line that we do not wish to push back. That's our property line that we are, please allow us to put a fence on our property line. Even though there's natural buffer behind our neighbor's backyard, it is our natural buffer that it's our responsibility. If somebody gets hurt there, it's our responsibility. Kids are riding dirt bike there and fall in the pothole of the groundhogs, it will be our responsibility. So even though it is natural buffer, it is our responsibility to protect, and it's not the extension of anybody's backyard.
The law allows for you now to put up a 4-foot fence in your front yard. 4 foot. However, you're asking for 8 feet, which is very intrusive to the neighbor's rear yards.
So can we have the 6 foot where the owner already have problem with it? Because we have homeowners already pro for 8 foot because the deer's invading their backyard too.
Well, in my opinion, you're asking for a deer fence because the deer are jumping the fence. So what good is a 6-foot fence?
So if I have the whole border 8 foot and only 2 houses, that's 6 foot.
I think what we're trying to do is compromise for your neighbors and for you to protect your vegetables and trees. If you want the 8-foot fence, we're willing to say, come off the property line 50 feet. If you don't want that, I don't see, or at least I can't vote for it. So you have to think about what you want to do.
But if they go back over 50 feet on the other piece of the property, what about the fence that's already up?
They have to move it.
The other one, they have to move.
It's not right.
Let me ask you a question.
And we're looking for
That
neighbors to
space
compromise,
between-
that's what we're looking for.
Between the property line, that's right, of course, behind your neighbors, and then you go 70 feet, and what's in that 70 feet? What's grown there?
It's just natural buffer, wildflowers,
It's what?
wildflowers.
A wildflower, so you're not growing any plants?
No,
in it?
absolutely not, it's
So I
natural
don't know
buffer.
why you wouldn't want to move it back, as Mr. Barnes says, 50 feet. You still have the beauty of it, and everybody'd be happy, and you'd have the deer protection.
Why would we? That's our property line. What if somebody gets hurt there? That's my property. I'm gonna be responsible for it.
Well, as
The
Mr.
code says 4 feet. You're asking for a variance for height. If you put a 4-foot fence, you could put it right up to the line, because you own that. But if you're asking for a height variance, because you don't want deer to jump over, we can't grant that. We don't want to do that if the neighbors don't agree with it. That's why they came, to show their concern. So what we're saying is, if you can compromise with them and move the fence back 50 or 70 feet, I don't think they would mind you having an 8-foot fence.
No.
But they have to speak also. But go ahead.
Now, example, the south side of the fence was used by our neighbor, he's a farmer, David, 1 acre. Exactly 1 acre was used by them for 5 years. There's no way we can protect our land without a fence. He used our land for 5 years. And even the neighbor right now, there's no fence in between. Before we put anything before, our land is totally destroyed.
It's also a dump yard for people.
It become a dump yard up there and become an extension of their backyard. They dump whatever they want to dump, the dirt, crib of weeds, trees, whatever they cut it out, they just put it there. There's no way we can protect our land without that fence.
It's our property line.
I understand that.
Yeah.
Yes, but it's
I have a
also,
picture to prove. And even the ladies just came out. His son is riding the bike just few weeks ago along the whole 9 yard.
So,
And
is
we
it
don't
about
want
the
them to
deer?
get hurt.
Is it about the deer, or are you trying to protect your property from liability?
It's the deer to start with, but then it is also the liability.
Well, you can by law now put a 4-foot fence up if you want, right to the property line. You want an 8-foot fence, you gotta compromise. And I'm only speaking on behalf of myself. I don't know how the chairman feels or the other board members, and I don't know how the neighbors feel, but let's hear what they have to say.
see, the biggest problem is, I know you weren't sure about the law, you should have come here in the beginning, before you did any fencing, and we
I'm
could have
sorry,
maybe
we-
worked this out. No, don't be sorry about it, just,
We
It
asked,
happens.
we
It
asked the
happens.
farmers, and they goes, I put up mine, you can put up yours.
yeah.
Yours is a residential lot,
Yeah, just,
it's a little different.
All right.
See if they look-
When you get up here, let's hear what you have to say.
I originally I wanted to see, because I have a 6-foot fence,
By your property.
woven fence behind my property.
Is it your fence or their fence?
It's their fence.
Do you object to it?
I covered it over with a couple $1,000s worth of trees. I don't even see it anymore. I did that. I put some arborvitaes in there, Leland cypress, went across the back.
You love them.
And where I did was where the poles are, I put a Leland cypress right on the pole so I don't see the poles are gone. And there's some open area where I can see across through Mr. Rockham's farm, all the way across Edwards Avenue. That's my view. And I blocked off the rest of it with the Leland cypress, and that's the way.
So if they change that to 8 foot, that would really kinda,
Well, they're not gonna, no, that's why I wanted to come here.
they don't wanna change it.
They're not, the
They wanna
yellow, I
leave the
wanted to
6.
see what was written. The yellow was written 6 foot, so this is what's submitted to the building department and the zoning board, and that's the way it's gonna stay at 6 foot. That's why I came here, to make sure it wasn't gonna be changed to 8 foot.
So
That
you
would've
would
messed
be-
it
No, that side is not getting changed.
up. That would've messed it up a little bit. That's
So you're in favor of their proposed sketch?
I wanted to see what the sketch was. The first time I came here, there was no fence line. But I
Okay.
wanted to see what was submitted to the town building department and the zoning to make sure that 6 foot wasn't gonna be changed to 8 foot, and I'll give you the plans back. I'm
Thanks. Yeah, but that's not changed.
Okay, I
There
just
it
was-
is now.
double checking, because some things
Yeah.
change from meeting to meeting, so I just wanted
So lots 8, 9, 10, and 11, they're proposing to have 8-foot fence right up against those property lines. And you're not one of those, because you're lot, what, 12?
I'm 12.
So then your
And lot-
concern is not,
Lot 13 has a 6-foot chain link fence across it. There's no.
So that's irrelevant
The owner
also.
put that, so I just wanted to see what was gonna go on, and just to double check.
so the fence was put up by the applicants
Yes,
on their property at
Yes.
6 foot.
yes.
Still has to be 4 foot. But you don't oppose the 6 foot.
No, but there's a story behind this whole thing.
Well,
I had a discussion with the town attorney. We went back and forth with the fence.
uh-huh.
Originally, I was gonna, according to the code, he went back, that they had to not just have one deer fence behind 200 feet of my property and not the rest of their property. So I had an agreement with the homeowner. It was originally 8 foot. I went to the town, the town attorney, and I agreed with the town attorney, talked to the homeowners to cut it to 6 foot and get rid of the 8, because the 8 was too high. And that's the agreement I came from, and I didn't complain anymore. Like I said, a couple thousand, I put the trees in front, softened it up, and that was fine. The question was, originally, was where the plot lines are, because there is a building plot, and then there's the rest of it. There's the 70-foot of buffer zone, and the rest of it is open space, natural,
Okay. So
okay?
bottom line is you're happy with your side of the fence.
I just want to make sure it wasn't changed. I don't want to drag it on.
Very good. That's okay.
Either way, it's still.
Marinaccio, Lot 8?
Did you, were you here?
Yes, I did.
Right, just state your name and your
I
address.
just want to restate that I don't mind the fence. It's behind my Lot 8, and I can see right through it. I don't mind. It's protecting the whole neighborhood.
All right.
So you're okay with 8 feet against your property
I have
line?
no problem with 8 feet.
Just let me have your name again.
Patrick Farinaccio.
Okay, so lot 8 is, okay. So,
And lot 9 is you, young lady, right?
Roberta.
And you don't want it?
absolutely.
Sure. Again, just state your name and your address. You've been sworn in.
Charles Cassar, Lot 11, 55 West Alfred Avenue. I'm not, I went on last time, sorry,
Right.
you know where I stand. I'm
Okay.
not going to go through you know where I stand with it. However, I do want to make note of one thing. There were some people that support the fence that spoke last time, which is fine, that they certainly are entitled to an opinion. But those individuals do not own property that is bordering that fence, okay? And as you said, 4 feet. I'm a visual person. I brought this to show. This is 4 feet, what's approved now. Now understand, this is 10
Allowed.
yards, 10 yards off my patio, okay? This would be 6 feet. I'm 6'3". This is what 8 feet is. And I'm a 6'3" man, and I'm taller than most. I can't reach it with my hand. Those are the poles that are 10 yards off my patio. I want everyone to see that.
Okay.
30 feet.
And as far as my other neighbor, Ms. McGray spoke, and she spoke about the fact that the original concern of the applicants was the deer and their fruit trees, and I'm sure that is an issue. That's 100 yards away from the start of this new fence. If they were so concerned about that, they could very easily run a fence across their own property, the width of their property, and completely cordon off that area and not disturb anybody else. And I'd be more than happy with a 4-foot fence. And if you consider a setback of 50 or 70 feet for an 8-foot fence, I would be fine with that too.
Would you take a 6-foot fence?
I would take a 5-foot fence. I'm willing to compromise.
I hear you.
Thank you very much.
You're welcome. Jeez Louise.
Oh, you got any
Well,
help
but-
for us here?
Anyone else want to speak?
Yeah.
What do you got?
But you see in the proposed, right? Take a look at this. They want to leave this 6-foot, these are 6-foot fences. These are proposed. They put the poles in, but they didn't put the fence up yet. Of course it is. That's why I suggest to go back 50 feet. And if they can't live with that, then we'll just deny it.
With the gate, and then they can put a gate there.
Well, but you know what? I think at the current status, yeah, it's a bunch of bull. I say we tell them, in the current situation, the way they're proposing it, we couldn't adopt it or pass it. However, we give them an opportunity to come back with a proposed alternative plan that we would accept. Why, why force them to? I don't know what they really want, but the only thing I can tell them is that right now, you probably couldn't vote for it the way it is. So we should give them the opportunity to come back with an alternative plan. And if they can't,
Okay. Okay.
does that sound?
Just pull that microphone down. Have you been sworn in before?
No.
Well, it's raise your right hand. You swear to tell the truth, nothing but the truth, so help you God.
Yes, I do.
Kindly state your name and your address.
Anne Marie Shatino. I live at 177 Donner. I'm like south of that property. It's probably lot number 2, Donna. And last year, the farmer put up fencing behind my home. It's 8-foot fence. You could see right through to Edwards Avenue. It's not an obstruction. I mean, if you want, you could plant trees in front of the posts, but you can see right through, all the way to the next road, which is pretty far away. So it doesn't obstruct your view at all.
Well, you know, everybody has their opinion, so, okay, thank you. All right. Well, let me just tell you folks, you don't have enough votes for the 8-foot fence, that's for sure. Again, I wish you would come here earlier. I know you didn't know, but we can't go along with the 8-foot and the other people's property when they object to it. There's no way.
All right.
Go ahead, Leroy, you got anything to say?
Well, I was gonna add to that, if you wanna submit an alternative plan, you could leave the case open if you wanna show a setback of 50 feet with an 8-foot fence. You need a variance for the 4-foot, the 6-foot fence you have already installed, because that's considered your front yard, so you would need a variance for that. So it's a little tricky here. If you propose where the pink is, to pull that back 40, 50 feet where everybody's happy in this room, then you would get something out of it. If you don't want to move anything or do anything, then we will vote accordingly. So we'll afford you the opportunity to resubmit an alternative drawing.
Yeah.
That's who we're addressing. But you need to come to the mic if you're going to speak.
Could we ask for 6 foot instead of 4 feet, because the existing, if the homeowner were to install their fence in their own rear backyard, they would most likely install a 6 foot, just like the existing owner had? The existing fence in yellow are installed by the homeowner in lot 13, and that's a chain link 6-foot fence. And also behind Mr. Donald's backyard, it's a 6-foot fence already.
So we
That's
would
the
have
same
to
one.
ask, this gentleman over here and this lady if they would object to a 6-foot fence.
I said I was okay with a 5-foot.
I will put 5 behind Chuck.
Okay, we got one 5-foot. And you, young lady,
I say if you're going 5, go all the way, it'll look nicer.
6-foot?
5
No,
foot.
5 foot.
5-foot.
If you're gonna do 5, you might as well just do 5 all the way.
No, but Patrick likes 8.
Patrick has beautiful vines that he's growing with beautiful grapes, so.
His
he
is
doesn't
6
like your
feet.
yard either.
Oh, Dawn, we'd have to write a real good decision on this one. We'll reserve the decision and then we'll address everybody's concern.
And
I
we'll
mean,
review.
essentially, we have to grant the variance no matter what. It's 4 foot's the law. So we could by
This one and this one.
by a resolution, try to stay that lots, looks like lots 8 through 11 would be a 5-foot fence, if everybody's agreeable to that. And then lots 12,
And 13.
well, this
Lots-
gentleman over here wants 6 foot.
Lots 12 to 13 is untouched. The one that's already has existing fence is not gonna, the homeowner already installed already, or the one that already has fence.
Okay, so is lot 13 and 12 okay with 6-foot fence? Who's not?
No, the man in the blue shirt.
Are you okay with 6 feet?
No,
Yes, he is.
he's already got the fence, he's got nothing to do with it. It's these
I
two
just wanna
folks.
make sure.
He says 5 foot. He's on the other side, Lisa.
She and I,
He's
No, I
over
know,
here.
but she still needs a variance.
she and I.
They're 9 and
we're
10.
miles apart. There's a gentleman in between the two of us. He is traveling out of town. I've spoken with him. He would prefer a 5-foot as well. His
Okay.
name is Rob Rizzuto.
Which lots are you again?
Right here.
He's
You're
on
11.
11, his neighbor's on 10,
I'm 11.
and Roberta
She's
is
9.
on number 9.
You're 9. Okay.
The man in the
So how about 11, 9, 10, 11, 5-foot fence?
9, 10, 11.
Okay?
You have a
Like I said
resolution?
before, 8, 9, 10, and 11, 5 foot.
Resolution? 9, 10, 11, 5-foot fence.
That's it?
9, 10, 11. What about 8, lot 8?
J. Patrick wants
He
8.
said, he said it's okay after 6.
Okay.
Good?
We have to write the
6 or
resolution
8?
to address each lot. So the gentleman that's in the back with the hat, lot 8. Are you okay with a 5-foot fence, or you would prefer an 8-foot fence? Okay, so let's just do 5 across the whole back as suggested. And then we would write the resolution approving the 2 6-foot fences on lot 13 and 12, behind lot 13 and in front of. Okay, so,
And
May I
then
ask one question?
with the
about
fence
here?
that's already installed, that's 8 foot along the, that's nobody, that's not in anybody's backyard.
well, it says proposed deer fence. Is there an 8-foot fence along the other side of the line?
It's already
Yeah,
installed.
it's already there.
So why'd you put proposed?
Um,
Okay, we'll figure it out,
Right,
don't
we'll
worry,
figure it
Wendy.
out. Okay.
Mr. Chairman, I move that the appeal of Wendy, how do you, Wong, which is Appeal 1821, be resolved with a reserved decision, and we will draw up a resolution specific to each lot so that everyone in this community can live in harmony.
Peace, love, and happiness, nothing
Second.
better.
I second.
We have a second,
Okay.
Mr. Chairman?
Mr. Barnes,
Aye.
Mrs. Worthington,
Aye.
Mr. Whitmire,
Aye.
and I vote aye. So the reserved decision will be next meeting, but basically, we agree with the 5-foot.
Motto.
What about the 8?
Yeah.
Carissa, you got your work cut out on this one. Have you been paying attention?
I think we have to
Or did you fall asleep?
I thank everybody for their time.
When is the next meeting, sir?
Next meeting is June
14.
14th. You're quite welcome.
That, what we said tonight should be approved on that night. If you don't feel like coming, give me your cell phone, I'll text you. Have a good night.
And again, I thank everyone for their time and patience. Us too. Okay, let's have a reading.
We did.
For what?
We've done it, Mr. Chairman.
Next one, next meeting.
Yeah.
Clarissa's on.
Next, appeal number 2018-024, J. Petroselli Development Associates, 428 East Main Street, Riverhead, tax map number 600-129-313, BC1 zoning, for variances and/or relief from Chapter 301, Section 249C1, where there is a proposed freestanding sign where the principal building is set back 7.6 feet and freestanding signs are not permitted where buildings are set back less than 20 feet. Section 249C4, where proposed freestanding monument sign with side yard setback of 15 feet and the minimum required is 25 feet. Section 254I, where proposed freestanding monument sign is internally illuminated, which is not permitted.
Well, one should never assume, but I assume that you're an attorney.
You got it.
You
Good
don't have to be
evening,
sworn in
Mr.
if you kindly name and address. please.
No, he's an attorney.
I'm an
I
attorney.
know that.
He doesn't have to be sworn in.
No, that's what he said.
I just
Good
said-
evening. For the record, my name is Eric Russo. I'm with the law firm of Van Brunt, Jesuiak and Russo with offices at 140 Main Street, Sayville, New York. I'm here tonight representing J. Petroselli Development Associates, the general partnership, 100 Comex Street, Ronkonkoma, New York. J. Petroselli Development Associates has constructed, as this board may be familiar, with the Preston House Hotel and restaurant, which is situated on Main Street. It's the tax lot 600-129-313 at 428 East Main. This board already granted previously a variance for that particular property as it related to setbacks for the rear of the property. I've provided you with a binder. The binder that I've given you indicates the application before the board this evening. It also encloses the Riverhead Town Architectural Review Board recommendation, which is a support of this application, subject to the approval of your board for the variance relief as requested when we appeared on April 19th for the submission, and then May the 2nd after they made their determination. If you look through the binder, you can see that there was a temporary certificate of occupancy issued for the hotel and restaurant. The hotel is a 5-story unit structure with approximately 20 rooms. And behind the temporary certificate of occupancy, because we're finalizing site plan issues with the planning department, it shows you the proposed sign, which shows the Preston House and Hotel, with the restaurant in the front and the hotel in the rear. It is a sign that was designed by Waddell Sign Company. The variance relief as called out by Ms. Collins is accurate. We've also enclosed photographs of the subject premises, and when you look in the binder that I provided you with the various photographs, you will see in red the location where the sign is to be proposed in the very front at the exact distances as was stated in the call of the meeting. There are 3 photographs showing you from the Ostrander side as well as the Main Street side, and then an aerial looking down where it's situated in front of the flagpole that is there presently on the premises. There is no signage on the site at present. The only site signage that you will see, if you're not familiar with it being a hotel and a restaurant, is a banner sign that's presently on the metal wrought iron gate in the front, which indicates what is there. The restaurant opened in February 14th of this year, and we're in need of having signage approval. We're only proposing one. There's no other signage provided. The site signage that I've also noted, there are various other signs on Main Street, so in keeping with the character of the area, ours is a very small sign. It is, and I can have Mr. Squires from Waddell describe it to you if you have questions, as we did before the ARB. Across the street is the new Atlantis sign that is there. You also have the ballroom sign, which is shown across the street, and the Hyatt Place sign. This signage will be similar to the Hyatt Place signage, only down on the ground. And I also show you across the street the neon lighted signs of the gas station. So in our opinion, based on 267B of New York State Town Law, it will not be a detriment to nearby properties or cause an undesirable change in the character of the neighborhood. There's no feasible alternative for the applicant to pursue because we only have a limited space to place the sign, given the size of the property. In our opinion, the relief is not substantial. There are no environmental or physical issues that are being created by the proposed sign. It's aesthetically pleasing. And in our opinion, it is also not a self-created hardship because we must identify the building and the business use, and this is the most appropriate, tasteful place to put it, given the nature and history of the particular structure. If you have any questions about the site signage, Mr. Squires can describe it further to you in detail, and we can go from there. Otherwise, I have nothing further.
I think you have all the bases covered. My baseball coach would be very happy with you.
I have one question, sir.
Yes, sir.
Why is the sign parallel to Route 25, where the vision is so limited? In other words, if you're going east and west, and the sign was the other way, you have vision a long ways.
Well, in
Right.
what I was
Hop up there,
I can
Mr.
have
Squires. You
I
have to be
can have
sworn in
Mr.
before you can say
Squires
anything.
describe it to you. I went through this with Lisa Drews and the applicant, Joseph Petroselli. They felt that this would be the most aesthetically pleasing way they've landscaped it and made it come up. They're hoping that based on the notoriety of the restaurant and its acclaim as a field to farm to field to serve, and they had an excellent review in Newsday. They got 4.5 stars. They're hoping people will come, because if you build it, they will come. And they're hoping that based on the hotel use and that, they will have enough patrons. So they were trying to find an aesthetic way to place it on site. That's why it was there. It wasn't the intention to see it on Main Street. It was more being able to identify it and so that everybody knows where the hotel entrance is and where the restaurant entrance is. Because there's no access to the restaurant through the gate on Main Street. You have to come in from the side.
Okay, that was just a question, that's all.
The ARB is happy with it, we're happy with it. How's that?
That works.
Is there anyone else to be heard on this matter? No sign people here? Okay. Who's got the reading?
That's a sign. You're good. Okay, I move that the appeal of J. Petroselli Development Associates of 428 East Main Street, Riverhead, in the DC1 zonings for a variance and relief from Chapter 301, Section 249C1, where there's a proposed freestanding sign where the principal building setback is 7.6 feet, and freestanding signs are not permitted where buildings are set back less than 20 feet. Section 249C4, where the proposed freestanding monument sign with the side yard setback of 15 feet and the minimum required is 25 feet. Section 254-1, where proposed freestanding monument sign is internally, illuminated, which is not permitted, be approved in accordance with the applications and sketches submitted.
Second.
Mr. Barnes?
Aye.
Mrs. Worthington?
Aye.
Mr. Whitmire?
Aye.
And I vote aye.
Thank you,
So
Mr.
your appeal's been
Chairman.
granted, and best of luck with everything. Thank you, Mr. Squires.
I
for
would just
showing up.
like to point out that we did submit all the notices and affidavits.
We have
and
them
letters.
we have them on file.
The only problem was, I provided you with the photographs, and I gave you the emails of the affidavits from the 14th and the 24th of May for the sign posting, but I was told they delivered those to Ms. Collins at her office this afternoon. I do not have them, I only have photocopies. If she received them, then I'm fine. Thank you,
Okay.
have a good evening.
You too. Thank you very much.
Pleading the fifth. All right, keep it rolling, guys.
Appeal number 2018-019, Bricksmore Riverhead Development LLC, 1762 Old Country Road, Riverhead, tax map number 600-101.1-1-2, DRC zoning, for variances and/or relief from Chapter 301, Section 249E4, for a proposed directory panel not coordinated in color or letter and is therefore not permitted.
Okay. So will you kindly raise your right, are you an attorney?
No,
You swear to tell the truth, nothing but the truth, so help you God.
I do.
State your name and your address.
Diana Laspisa with Morano Expediting Services, 4 Hamilton Court, Quorum, New York, 11727.
Okay, now you want to put different colored signs and whatnot up there?
Correct. So I'm here before you on behalf of the new tenant, HomeSense, which the building is under construction, and they're requesting permission to have their 2 tenant panels to comply with their corporate colors and font and not really logo, but they wanted to be able to use their corporate colors on the signage, and I understand that that is not allowed. They are required to comply and be uniform. I do believe there was approval granted, I want to say last year, I do have a copy, for Marshall's Home Goods. Right now, currently on the site, and I do have pictures for the board of the current directory panel, and Costco, Marshalls, and Home Goods all are using their corporate colors. And, you know, so it does increase visibility. I do understand that this is something that is very, you know, seems to be very frowned upon because you're put these codes in place to kind of create everything to look more uniform. HomeSense stand on it is they're new to New York. It's a new chain. They've been around. They have 3 locations in Massachusetts and 2 in New Jersey, and only one that just actually the grand opening was today in Comax. So people don't know from around here, HomeSense, you know, that have may seen them in Jersey or seen them in Massachusetts. They're not going to be familiar with it without seeing their corporate colors and signage. So they do feel that by not having that by the curb, it will really reduce the foot traffic that they could potentially get in until they become an established chain in New York. I do have a photo, I'm sure the board's somewhat familiar with the property.
Bring that up, please.
Okay, so I'll bring up a photo of the subject parcel, the signage, and that's existing. And then I also did take some photos just of other shopping centers
A
along.
lot of those things are old time, but go ahead.
And I do understand that.
I mean, the ARB said no, so let's see what
Well,
you got.
see, I guess what I'm confused about is the application hasn't been before ARB yet. The only thing that we went before, I know we still would need their approval on it, but, oh, here's the other pictures too. Before ARB, the only thing that we went before them for was the 2 wall signs and the under canopy sign.
it was my understanding we weren't even allowed to go before, and I did speak with Carissa at one point on this, because we thought we had to go to them first,
You
but
said you had approvals from the other signs?
not I personally got them. I have a copy of a decision, I only have one copy with me.
Well, we can take a look at it, we'll give it
Yeah,
right back
that's
to you.
fine. Let me just find it, I dug it up before.
I don't think any of the Costco, the signs of the shops at Riverhead, I don't think any of those signs have been approved.
Marshalls and Home Goods, I do definitely, let me just find it, I dug it up. I wanna say
The
it was,
signs on their building may have been approved, but I'm not sure about a directory
no,
sign
it
approval.
specified the directory
Okay.
panels.
It probably has been approved, I don't recall doing it. But-
Oh, here we go. So this is from, I guess they had several meetings, February 25th, 2016, April 14th of 2016, and April 28th of 2016. And the third relief granted, I believe partially their relief was denied, but it was granted allowing two, well, it says two primary anchor tenant panels, but when you look at the sign, it's actually three, because Costco is their main signage, and then Marshalls and Home Goods have their typical standard signage. Owners, occupants to display signs of different size, coloring, lettering, shapes, and logos, and which are more prominently displayed than other display signs as proposed and requested contrary to the requirements. All other aspects, so moving forward, of the directory sign in question shall conform to chapter 108. So that's, you know, why we're before you. And Marshalls and Home Goods, I mean, they do have two entrances, but essentially it's one store. You can actually keep that if you need. I think I have it in my email. I can get it.
Okay.
This follows the Dick's signage. And we gave them the two primaries have their colors, everything else was black and white. That's the last one we did.
And, you know, to be honest, the Marshalls portion of the center and the Home Goods portion of the center, if you separate them, because if you go inside, it is one big store. HomeSense will actually be a much larger store than Marshalls alone and Home Goods alone. You know, but their main concern is because they are new to New York, and they're just, you know, when you drive, you see Marshalls, everybody knows what Marshalls is, everybody knows what Home Goods is.
Yeah, but, you know, then it also says,
Will comply.
you know, it says, they did approve two primary,
That's correct.
Yes,
but it also says, all aspects of the directory sign in question shall conform to 108, section 108-56.
That's correct.
yes, so meaning that doesn't pave the way for other future tenants is what, yeah, no, I understand that, and that's, I mean, if it didn't say that, I don't think we would,
Well, with Dick's, Dick's was the primary, and so was the Christmas store shop, and then the rest of them were all in the same lettering, instead of all this Technicolor. And I think the ones that are in the same lettering are much easier to read than when you get this Technicolor picture up there. And we're not interested what corporate requires. We're trying to
no,
deal
and I
with the code
understand that, and
Riverhead
there's a
requires.
reason, you know, why the town implements these codes, and I do understand that, you know, and we do respect that. I mean, we tried explaining to them, and I think at one point I had, you know, even expressed to the secretary, you know, because I know the ARB, if we make it to that point with the application the way it is, I don't know, you know, whether they will even approve it at that point, and that's would
Well,
be
we
our
got,
next
we
step.
have some paperwork here from the ARB saying, you know, HomeSense and does not meet code. We do not recommend ZBA approval.
Oh, okay. I didn't realize that they did in our office. I had, okay. No, that's fine. I mean, but when we were before them, that meeting, I actually had a scheduling conflict. We had 5 hearings that day, so I had somebody else attend it, but it wasn't, we weren't before them. Like, the building department didn't bring to them all the paperwork for the directory panel, because I
Right.
was advised that they don't even have really jurisdiction to even grant an approval, even if they wanted to, which I understand, I don't think that they do, until the board makes their decision, you know? And we did express this to our client, you know, the, I guess, feedback from the different departments, you know, but they did want to try and pursue it. They're really just trying to get out there as a high-end furniture store.
Well, the only problem is, you know, we approved that, and then it just, you know, opens up the floodgates, and we can't.
When that application came in, it was referred to the ARB for their opinion on it, which we do very often with a lot
Oh,
of the
okay.
signs. And that came back with
Oh,
their
okay.
opinion,
Okay.
which has been our opinion of it.
You know, I wish there was a better signage laws, but whatever, just the way they are.
I mean, I don't know if this is something that the board would somewhat consider, because of the fact that it is
Tell you what we'll do, well, let's put this off to the next meeting, we'll talk it amongst ourselves in the ARB, and we'll see.
And why don't you go to whoever and see if they wanna, see if they can conform with what was done like at the Dick sign and what it says, you know, to that particular part of the law.
Can I take a look? I didn't keep a copy of the pictures to have in front of
Sure,
me that
oh,
I gave you.
absolutely.
Can I look at that?
Absolutely, take them with you.
Well, you can keep them. I have them in my
'Cause most of
camera. I'm
those
just
are all-
curious
No,
if
no,
we
take
keep
'em with you.
mentioning
Those
the
are all
Dicks.
before our decision, really.
Oh, okay. No, I see what you're saying. I mean, it is different colors. You know, it may not be complete, I mean, I know what we're proposing is not just different shades of green, but that one does have the different colors. They're not uniform. Here, I'll give them back. I don't need them.
Okay,
Yeah, because I can read print.
all right, so let us do this, we'll talk among ourselves, we'll get in contact with the ARB, and then,
And why don't you talk to your people, your applicant, whatever it is, see if they want to conform, how they
Well,
can
no,
conform.
yeah, we've had that conversation prior, and that's kind of why I'm here tonight. But, you know.
we'll see you on the 14th of June, and
Is
we'll
that
discuss
when
it.
the next hearing is?
That's when the next
Okay.
one is.
And then will it be like the other ones at the first, is that?
What we'll do, we'll make a decision that night, one way or the other, you'll hear from us.
Okay,
In
Okay.
fact, what you can do is, you can check in with Clarissa, and we'll discuss it before the meeting. Maybe it would save you a trip,
okay,
all right?
okay,
Thank
thank
you.
you.
Thank you very much.
Tell me, adjourn.
Yes, adjourn that to the June 14th meeting.
Mr. Chairman, I respectfully adjourn appeal number 2018-019 to June 14th, 2018.
Second.
All right, Mr. Barnes.
Aye.
Ms. Worthington.
Aye.
Mr. Whitmire.
Aye.
I vote aye. Okay, then, young lady, off again.
Appeal number 2018-022, Overlook Drive LLC, 254 Overlook Drive, Aquabog, tax map number 600-113-111, RB40 zoning, for variances and/or relief from Chapter 301, Section 17, where the proposed impervious surface coverage is 15.1% of the lot and the maximum permitted is 15%. Proposed front yard setback is 23 feet, where the minimum required is 50 feet. Proposed side yard setbacks are 13 and 15 feet, where the minimum required is 25 feet. And the proposed combined side yard is 28 feet, where the minimum required is 55 feet.
And good evening. You swear to tell the truth, nothing but the truth, so help you God.
I do.
State your name and your address.
Edward Hocker, 242 Overlook Drive, Aquabog.
You have the floor.
Okay, I wanted to, I know you have all the surveys.
Do you have your postings and everything else?
Yeah.
You got it? Okay,
You have
great.
all the surveys, but I just bought extra copies because I made a couple of what do you call it, highlights on them that when we talk, you can see better. And then there's, all right, so I applied, I got the related info packet that everybody should have. The first rejection letter, when I applied in February of 17, I have that first rejection letter, and you have the survey from that I just handed over to you. And then I have the second rejection letter where I made all the changes, and I have the new survey. And this is the one that we're discussing tonight. I just wanted to point out the changes that were made. So, the concerns, I guess, are, I mean, it's pre-existing, single and separate lot, pre-existing, before the zoning change, and I have no alternative but to, you have the survey.
I'm looking at it.
Yeah. And the DEC, the set, the layout, the footprint is what it is because there's nothing else I can do. The DEC has me pinned in, and that's where it's at.
Now, is this gonna be your own personal house, or you building
Yeah,
this for spec?
absolutely. You know, we live next door. You know.
Yeah.
And, you know, had this lot for over 30 years. I must have spent 50 grand on taxes. We want to downsize. We want a small, nice house. It's not going to be a junk shop. It'll be architecturally designed. And the only building envelope I have is what I just presented to you. There's nothing else I can do. I mean, if you have, you see that I had original DEC permits, and you see the setbacks. You see the, obviously, I think some people go to inspect the property. I was told by Carissa, I think people come look at the property, so you know what,
Yeah, we would have.
what we're talking about. I mean, it's a little lot. I'm the last lot left on the whole peninsula with any cedar trees, which I really like. The backyard buffer is about 30 feet long, something like that. DEC doesn't want it disturbed. I don't want to disturb it. I just want to have it nice. I just want a nice little place to live. And any questions?
Who's in charge of the roads there?
That is our major problem. Oh, that's another thing.
Excuse me, do you folks all own the roads? Is that what it is there?
No, it's a,
Private dirt road.
it's a real problem. You know, the town adopted that road into their system, but they will plow it and they will repair potholes once a year. So we're hoping that when Binkus, I understand he's gonna get a subdivision eventually, and he will pave the first half of the road, because that'll be a requirement. Then the rest of the road where we live, we can handle on our own. And like Geo is supposed to come and fix the potholes once a year anyway.
So this house only has 1,128 square feet,
Yeah,
right?
I reduced it, I even reduced it from the first time. There's no, I mean, it's a small house, but it'd be like a condo virtually. Upstairs, one half of the upstairs would be 2 bedrooms and a bath, and the other half of the upstairs would be combination kitchen, dining area, and large living room.
So it's elevated to match FEMA or whatever?
Yeah, you know, obviously you gotta do what's required.
Yeah,
The
you gotta
town, the
design
town's
it.
gonna enforce their building plans on me, whatever I apply. They're not gonna let me get away with anything.
Well, you never know. I don't have a problem with it.
I don't have a problem with this.
All right, I just have to,
I mean, it's,
We have a couple letters of opposition here, one from Mr. Klein, who lives at,
He lives in Melbourne, Florida.
Mr. Klein.
yes,
He's the fellow that lives there about
254 Overlook.
Excuse me?
he'll have his turn to speak.
He's at 254 Overlook. I don't guess he's not gonna be here.
Yeah,
I'm
someone's
too
waving.
busy.
No,
Oh, there he is, okay.
No, we're here on the application, not for him.
Okay.
So what's Mr. Klein's objection?
Well, they're written letters to us.
So what his,
It's typical, you know, it's too
Yeah.
small, it's too big.
Too small, I know, that's it. One person says it's too big, the next person says it's too small, and I say it's the only thing I can do.
It doesn't look to me to be opulent in any way. It seems to be fairly designed to meet the criteria of that lot. It's a small lot, but that's single and separate ownership, you have a right to build on it.
Good.
That's the way I see it.
Okay.
I don't know if anybody else objects to it, we'll hear from them.
okay, we have another letter here from three other neighbors, the Leopards, Goldbergs, and the Canopopolises.
Okay.
So, anyway, four of your neighbors are in opposition.
Okay.
Okay,
Well, most of the remarks are that the place is too large, the setbacks are too great, you know, the variances that are being,
Mhm.
you know, when you drive through that area, and I tell you, it's a great area, you know, it's got all that creek front and the waterfront.
Right.
On the other side, you know, a lot of different things in there as far as houses. I mean, there are houses that are postage stamps, and then there are houses that
Exactly,
are
I mean-
almost built out on the whole lot, so.
I can point out on the, on this map that I gave you guys, here's me, and there's Canopolis. That was, he had to go before the Board of Appeals. He didn't build it, but, I think Petrovich built it. They had to get approval, that's less than an acre. Up here, number 4 is less than an acre. And obviously, go back up the street, you know, you see, you know, where Dwayne is. Dwayne's been there forever. And I'm a live and let live guy. I don't understand people opposing this. That's the way I feel about it.
okay. Let's hear anyone else. Please have a seat.
Sure.
Require a card for appearance.
We'll take it though.
Hi, Mr. Chairman, members of the board. Chris Coscignano, Son Ward Coscignano, 333 Earl Ovington Boulevard, Uniondale, New York, 11553. I'm here on behalf of the Capitola family, who owns the property immediately across the street and immediately adjacent to the subject property. Their daughter, Michelle, is here with me this evening. She's a trustee of the trust that owns the property. I want to compliment your offices. I had called during the week to get further information. I was going to seek an adjournment. They told me it's not your policy because we did want to meet with some of the other owners. Some are unavailable. My client, the principal owner of the trust, is traveling out of the country right now, but they had their daughter come instead to allow us to move forward this evening. We really hope not to appear before you. We really don't want to object to their neighbor's potential development, but my client felt they had no choice, and they were in contact with 4 of the other neighbors who felt the exact same way. I'm not representing the other neighbors, I'm only here for this one particular client. I think the letters that were sent to you express some of the objections very well. On behalf of my own client, they had spoken to the applicant and they offered to actually buy the parcel. They were still willing to purchase the parcel at the property owner's cost to preserve the parcel. In terms of the variances, I know there are several, and I'll discuss the variances. But one question I had that perhaps you can answer for us is with regard to the right-of-way, the roadway. We are unsure as to the status of that roadway, if it provides frontage to the property, or because it's a right-of-way, if there isn't frontage for the property, and that might be a variance that still is necessary for the applicant. So that's more of a housekeeping question I had for you or the building department. I would think that if it's a right-of-way, this property has 0 frontage and then needs a very substantial frontage variance. But that's just my interpretation.
Well, we go by what the building inspector issues as a denial letter.
But I think they might have missed a variance.
He may have.
Okay.
You may want to take that up with him.
Okay. Well, I just like, before there's any approval made or any decision made, I'd just like to ask the board to consider that. With regard to the front yard setback, the requirement is 50 feet. 23 feet is proposed, which is a 22-foot variance. That is a 54% variance. I know there are challenges with the property. With regard to side yard setbacks, which directly affect my client as well as the front yard setback, the side yards proposed are the shortest one is 13 feet, and that represents a 48% variance. With regard to the combined setback of combined side yard setback, it's 28 feet versus the required 55 feet, which not only affects, again, the owner of the property who may sell off his piece, it directly affects my client. That is a 49% variance. So these are very, very substantial variances, and I think we have to admit at times some lots are challenged, but not everything can be built upon. Perhaps this is something that should be sold to a property owner who wants to preserve it and preserve the vista for the other property owners on the block, and not have the property owner suffer any financial loss. My client's not looking to hurt the applicant, but did offer to purchase the lot, as I mentioned before.
Could you tell me how much?
I think that was a discussion they had between, but I believe my client said they offered $200,000 for the lot. Well, I'm making the representation as an officer of the court, that's what my client told me.
Can I hear from the client?
And, excuse me?
May we hear from your client?
Sure.
Oh, you're an attorney as well? Just state your name and your address.
Michelle Capitola Johnson, 9. Yes, sir.
Could you come up here one moment and identify your home for me?
Sure.
Please. Because when it's across the street, there's 2 homes in
Was that
question.
Neil Kopp's house?
I'm sorry.
Was that Neil Kopp's house?
I think it may have been
K-O-P-P?
previous to my father owning it.
Right,
Yeah.
right. That's what I
Just
was
mark the
asking.
spot, oh, you got that, just mark the
That's a
spot.
very
where
nice
you're-
little house.
His lot is marked there.
So confused with it. Okay, this is this home. So this would be
Yeah, that was,
our property. And then
he did the
there is
subdivision,
right
actually.
here, and I don't see it here, but there's presently, as part of my father's parcel, a little parking spot so that you could park off-street.
Yes,
and not-
I saw that.
So that, I denoted that for you as well.
I remember when that house was built.
Which one is it?
the one you had.
And I think
No.
he died,
This one.
yes, and like his lovely.
Yeah, very nice.
Here's the parking spot.
Sorry to
Yes,
get off
this
track.
one, no, it's this one.
This one, okay, yeah, she just.
But anything further, should I step back?
You can step back, because we'd like to ask you a I would like to ask you a question. You offered him 200,000
So
or?
I was not part of the negotiations. In fact, we just met this evening for the first time.
Okay.
My father had a long planned vacation, just got notice of this appeal this past week, so he asked me to come in his place. I was not part of any negotiations. He did tell me that he offered to buy it. He did not tell me personally an amount. Perhaps he did tell counsel. I do believe, and perhaps the neighbors could correct me if I'm wrong, that they said they wanted to get it appraised first, is what they told my dad, and what he told me, that he was told they wanted an appraisal of the lot first.
And we would not have issue with that at all. That's one of the reasons I
You have to speak into the mic,
You have to
sir.
speak in the mic.
I'm sorry.
That's okay,
I apologize.
nothing to be apology, that's all right.
I should do it right.
Where is he going here?
When I spoke to my client, it's one of the reasons I called the office, and the office was very helpful. I appreciate what was said, but I requested an adjournment so that we could potentially have I said I would come this evening or write a letter to seek an adjournment so that we could have some dialogue with with the applicant and maybe pursue further
Well, we're
conversations.
not making any decisions tonight, so you can have till the 14th of June.
Okay, well, we gladly would have conversation, but my client is also, I believe they're in Amsterdam now, so they are traveling and could not be here. Planned anniversary trip, I'm told. I'll just,
They didn't want to come here, and instead they went to Amsterdam, they got some nerve.
you got stuck with us, sorry.
All right.
Yeah, go ahead.
Yeah, can you clarify your concern regarding the potential development, the lot that's, you know, the subject parcel's issue with the roadway? Are you suggesting that they have no access to this parcel?
No, not at all. I think there's something called a 280A variance, if you don't have frontage of proper amount, which is, I believe, the minimum you could possibly have is 15 feet potentially under state law. But, because you need an emergency vehicle to come in. But if you're on a right-of-way that goes out to a main road, you don't get credit for any frontage on the property to build a new development. You get zero frontage. You have lack of street frontage. You have access, but you have lack of frontage. So I believe a variance in your code would be zero frontage at setback.
Well, it's funny that you're talking about Neil Kopp's old houses, which is your parents' now. Just a little history on it. He put up pillar walls, Mr. Kopp, and then he tried to put gates across them. Couldn't get,
But
you remember that? But he couldn't get, we couldn't get fire apparatus through. So, needless to
I'm not
say-
making the argument that none of the houses should be built. I'm
Yeah,
just,
that's
I'm
what
just.
I'm wondering, 'cause everybody would have
I'm
to-
citing just the fact that one of the
You know-
requested variances would be missing from your.
I understand that.
It's just
But
a
if you look
technical
at the
housekeeping.
practicality of the house, if they have a right to build on it. The size of the house on the first floor is 1,100 and change square feet. If you really think that you can make them an offer they can't refuse, then do it between now and the next meeting. That's all I'm suggesting. They may not want to sell, and they may want to downsize, and that's the end of it. But
But
I'm
I'll
quite sure
finish-
they're approachable.
I will have that discussion. I'll
Good.
finish my argument, if you will.
Sure.
I still probably can't sign on to the fact that everything should be developable, and certainly not automatically in the manner that they want to develop it. I think anything could be modified. But I'll just finish my presentation, and we'll hopefully have some
Understood.
continued dialogue. But I respect what you're saying, and I know that if it's a single and separate lot, it can and should be developed, but, I mean, that doesn't give them the latitude to ask for these substantial variances. So I know the board is charged under 267B of town law, considering the benefit to the applicant and weighing it against the detriment to the health, safety, and welfare of the neighborhood or community. And I know you'll use the 5 factors that I'll follow with to make the determination, the first of which is whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby property would ensue from this development. We feel that both an undesirable change would be made in the character of the neighborhood, and we certainly feel that there's a detriment to nearby property owners, especially to my client with its front setback issues and its side yard setback issues. These variances are too substantial to not affect neighboring properties. Can the benefit to the applicant be achieved by some other method? Yes, the applicant can change their development and not have such substantial variances. The third factor is whether the variances are substantial, and I think I've shown you that almost every variance I mentioned was in the neighborhood of a 50% variance and even greater. So I think those are very substantial variances, and I think that alone would negate the potential development of the property. The fourth factor is whether the proposed variance will have an adverse impact on the physical and environmental condition in the neighborhood, and we believe that is the case as well in accordance with factor 1. And the last factor, factor 5, is whether the alleged difficulty is self-created, and in fact it is, because the property was purchased with these drawbacks. This is not something that just happened. This is a property that was purchased knowing about the shortcomings of the property. And again, we'd love to have dialogue with the owner about a potential purchase so we can preserve the property the way it is now. My client is not in the interest of buying it to develop it, rather just buying it to keep it the way it is now. So in that regard, we believe that if it were to be developed in this respect, the variances are too great. The application is unfortunately too substantial in terms of variances that are before you to be approved. So, you know, we hate to ask for the case to be denied. We hope maybe the case would go on reserve decision and we could have that dialogue if you guys are in a rush.
We're not gonna close the meeting.
We can leave it open and
Yeah.
We're
adjourn
leaving it open.
We'd love you not to have to issue a denial because that
We're
would.
not doing anything tonight.
Yeah.
We're adjourning it to the next meeting.
I just
Okay.
have one.
Go ahead,
Just
go on.
quick question. Your client's house, when it was constructed, are you aware as to whether they had received any variances?
I am not familiar. I don't know. The one thing my client said to me in the day or two before he literally got on the plane was, the other neighbors objected. He sent me the objection letters, so I received copies. And he said to me, and I don't know if it's true, he believed that everybody built in compliance with the code. But I don't
Excuse
know
me.
that as a fact.
Yeah, we'll have to
That's,
research that.
Yeah.
I
I
don't
don't
know
wanna
how
make
many
that
houses they
representation.
have with a 50-foot front setback on that road.
That's the first question that came to my mind,
I mean,
and
there's not many. Let me
Yeah.
tell you, once you get through the pothole, you know, trip, and you get down there, the point is beautiful. But I like to know why it doesn't matter as
Because I
far as
think
I
you'd
know.
have
no,
to
I had
weigh
a
the
similar
subs-
question
whether
that
the-
you just said.
Whether the variances were substantial would have to be evaluated in the context of the other variances that may have been granted to property owners in the vicinity.
Agreed, as would the front yard setback, which I absolutely thought of, you know, just like yourself. And if you wish, well, you know what, we will do some of that research in between now and June 14th.
Yeah, that was a subdivision, Mr. Cobb
June
filed,
14th?
there were 5 lots.
Yes, sir.
June 14th.
Just giving you a little history, it was a subdivision, it was 5 lots at the end of the point. Mr. Kopp was the subdivider. And I believe what the planning board did at the time when they approved the map, they also sought the variances through building envelopes, but I'm not 100% sure, but that was at least 10, 12 years ago.
Well, the least we could do is undertake that research. and,
Absolutely,
you
yeah,
know,
we're gonna put it
we
off
will
to the
gladly do
14th,
that.
so.
And no one knows the area better than your board, so we'll do some homework.
Okay.
We all will.
And thank you for your time.
Thank you.
And again, we will speak immediately. Thank you.
We have a gentleman who wants to come up and say something. Please step up. And if you kindly raise your right hand, you swear to tell the truth, nothing but the truth, so help you God.
Victor,
Yes, sir.
Just state your name and your address.
Victor Ozeri, 228 Overlook Drive, Akabog. I am here to state that I do not have an objection to Mr. Hocker and Mrs. Hocker building their house there. I have quite a substantial house adjacent to this property, right? I'm the closest neighbor to Mr. Hocker, on the same side of the street. I do believe in a live and let live world. The Hockers have been on that property for decades, in a community that has people living in their properties for decades. They want to size down right now, and I believe the real objections, which we understand as people that bought on the other side of the street, do not want to lose their view. And the view belongs to Mr. Hocker at that portion of the road, etc. Now, we've got all kinds of things going on that road. We've got everybody living there from Jed Clampett to a couple of millionaires. And, I don't see the point in if he's going to build a lovely, cute home on the property. Lord knows we see them all over the place, even in the ritzy Hamptons. You see skinny houses and tiny postage stamp homes on lovely pieces of property. As his neighbor, I do not object, and I believe the neighbors are getting together, and they're all nice people, they're good people, and I get what they want. But what they really want is somebody not to build a smaller house. And at the end of the day, all of us have money on that street, but we shouldn't be pushing it around to deny people that have lived on a property for 40 or more years to have to move off that property in order to size down when they own another lot. and I would recommend to the board that they grant the variances and allow Mr. and Mrs. Hocker to build their dream home when they've finally gotten rid of all their kids.
Thank you very much.
Thank you, I appreciate it.
You're quite welcome. Listen, there is an attorney who doesn't want one more thing, so go ahead, step up there and stage it.
Just
Take
a
your time.
point of clarification, just speaking on my client's behalf who couldn't be here, and I know his daughter is now a little bit upset about it. We're not looking to push anybody around.
We hear that.
We are looking to have dialogue and, you know, try to work something out, because if they're looking to make some changes in their life, and we can work it out so they're happy and they get to sell the property to my client is willing to, you know, use his money not to push people around, but to buy the property, so.
Like we said earlier, peace, love, and happiness, that's what we're about, that's all.
And just
Thank you very much.
one last request would be,
Sure.
could we have a copy of the drawing so I could take it back to
Sure.
my client, because we don't have that yet?
Yeah.
Okay.
We don't have drawings of the house, we just have,
Just the footprint or what?
yeah, sure.
You want the survey?
Whatever the exhibit was before would be great.
He wants a copy of the survey?
Yeah. That's cool.
Thank you, Irving. Thank you for your help on the phone.
All right, I move that appeal number 18-22, Overlook Drive LLC at 254 Overlook Drive, Aquabog, be adjourned to the June 14th, 2018 meeting.
Second.
Mr. Barnes?
Aye.
Mr. Worthington?
Aye.
Mr. Whitmire?
Aye.
I vote aye. See you folks on the 14th.
Thank you.
Thank you very much for your time. Mr. Cuddy, hold on a second while we get our reading done, but it must be attorney's night out. Okay, very good, thank you.
Thank you. Get out of here early.
No, that's not it.
Wait, no, if you want to stay with us.
I'm gonna be just packing up, so.
Yeah, sure. The call's already running. I'm only.
Again, Mr. Cuddy, always nice to see you, but let's have a reading.
Appeal number
Mr. Charles.
2018-023, Raymond and Cynthia George, 1459 Conic Bay Boulevard, Laurel. Tax map number 66941, RB40 zoning for variances and or relief from chapter 301, section 15A1A for a proposed accessory detached garage in the front yard where one is not permitted.
You have the floor, Mr. Cuddy.
Thank you. This is an unusual lot in that it's in South Jamesport, and it's bigger than the requirements. It's 77,000 square feet in the RB40 area. On this 2-acre lot, Mr. George, who is here with me tonight, wants to erect a house, a garage in the front yard, not a house. And he has an existing garage that is in the front yard, and that was approved. He also has a pool that's essentially in the front yard that was approved by this board years ago. He wants to take down the existing garage and erect another one so he can store cars and boats in the new garage. He's going to be set back 188 feet from the property line. And he's got great depth to this lot. And what he wants to do is to use part of the garage, as I said, to store boats. He's not going to use the upstairs, that is the second floor, except for storage. I don't think that this has any impact on the neighborhood because there are other garages that are similar to his that are located on lots nearby that are in the front yard because they don't have really an alternative. And in fact, there's no significant environmental impact that this is going to have. And as I just said, the alternative is not to have a garage because in all those houses are up right on the water. And so you only have an area in back of the house essentially, which is the front yard. And so
It's
we
kind of silly.
put a
I mean, for me, the front of the house would be the front yard, and that's the backyard, but whatever.
In other towns, they do it that way. They actually reverse it when you're on the water. As an example, in Southold, they have a section of the code that says when you have a waterfront house, then you can have your backyard against the road. And so then you don't have this problem.
All right. I don't want to cut you short, Mr. Cuddy, but anybody have any questions on the board? We've looked at this pretty good. We've been down there.
There's no bathroom facilities or anything upstairs in the garage? or
Not upstairs, no. Downstairs only.
So like the mother-in-law's not gonna live up there?
Absolutely not, no.
Because I could do you a favor and have it and deny it. Okay.
All right, who's got the reading?
Oh, brother.
I do. There's no one else to speak out there, is there?
I don't see anybody popping
It's a
up.
quaint little property, I may say. Very nice.
Beautiful. Move that the appeal of Raymond and Cynthia George, 1459 Peconic Bay Boulevard, Laurel, SCM or Suffolk County Tax Map number 600-69-4-1, RB 40 zoning, for variance and relief from Chapter 301, Section 15A1A, for a proposed accessory detached garage in the front yard where one is not permitted. Be granted in accordance with the application and sketches with amendments thereto, if any, as filed with the building inspector.
Second.
Mr. Barnes?
Aye.
Ms. Worthington?
Aye.
Mr. Whitmire?
Aye.
I vote aye. Mr. Cuddy, you know the process, so best of luck. Mr. George, all the best. Enjoy your summer. Do we hear a motion to accept the meeting, the minutes of the last
So
meeting?
moved.
All in favor?
Aye.
I make a motion to adjourn.
Second?
All in favor?
Aye.
Aye.
Thank you very much.